Welcome. I call this meeting to order, and welcome to the Tuesday, June 21st, 2016 Land Use Committee. Our first item of business this afternoon is approval of our minutes from February 16th, 2016. Can I have a motion to approve?
So moved.
Thank you. A second?
Second.
Okay, all in favor, say aye.
Aye.
Opposed? Okay, hearing nobody opposed, the motion carries. The minutes are approved. And our one and only item on the agenda today is General Conditions Presentation Updates by Shannon Verhage, Assistant City Engineer. Welcome, Shannon.
Welcome. Good evening. And as Councilor Kiley said, I'm Shannon Verhage from the Engineering Division. And I wish I was here to talk about a glamorous subject like pavement management or rail redevelopment, but I'm going to talk about general conditions today, and kind of, nevertheless, it's still an important topic for the Engineering Division because it's one of our documents that really controls how we do business with our contractors. First thing I want to do is actually introduce a few people that are here today that really did a lot of the heavy lifting with this, really did all the legwork, spent countless hours in meetings with the contractors, kind of going over line by line. And that's Diane Best from our legal team, and then Josh Peterson and Brad Ludens. And those are our two principal engineers for construction. And they actually are they're really the heart and soul of our construction program. They actually each lead a team of project managers who carry out the construction program. So those two people, they're basically tasked with managing anywhere from 80 to 100 projects a year. You know, our construction value, you know, $60 to $80 million worth of contracts a year. Most of that work funnels through Josh and Brad's team. So I want to really give them credit for doing the work on this project here. So with that, what are the general conditions for public improvements? You know, it's a 65-page document, and what that really does is it sets forth the responsibilities of the city and the contractor during the construction process. It helps control the bidding, award, construction, and closeout procedures. And I kind of want to emphasize these general conditions really apply to our street and utility type projects. Those generally are kind of on a unit price format where we pay for everything kind of on an individual basis, like we pay for every ton of asphalt that goes down, or square yard of pavement, or lineal foot of water main. So everything's paid for on a unit cost basis. So that's what these general conditions cover. There's other types of projects out there, like architectural type building projects, new libraries, fire stations, and stuff like that. Those are governed by the AIA, American Institute of Architects, general conditions document. That's not what we're here to talk about tonight. And those types of projects are usually lump sum instead of a unit cost type project. And then this doesn't apply to our private development work, where a developer comes in, builds a subdivision, does all the infrastructure, and dedicates that to the city. Those general conditions per se are governed by the subdivision construction agreement, just a little different format, so there's a different document for that. But this, what we're talking about today, covers most of our street and utility projects that we do. Just for background, we periodically review these documents, and 2013 was our last minor revision. And then we have to go back to 2010 since we had our last major revision where we did kind of a major overhaul of them. So the work that we completed to date, this has actually been an ongoing process for nearly 2 years for us, where what we started is we compared our document against several industry documents, including the South Dakota Department of Transportation standard specifications. Their type of business and our business are very similar. We're both in the business of building highways. They don't necessarily do so much utility work, but actually our document is kind of based off the DOT document. When ours was originally created years and years ago, that was kind of the foundation of our document. So we really actually closely mirror the two documents, are pretty close. And then we also evaluated against the EJCDC document. It's the Engineer Joint Contract Documents Committee. This is a national document that's used across the industry. We compared our document against that, as well as the Iowa Statewide Urban Design and Specifications, commonly referred to as SUDAS for the acronym there. There is a good share of Iowa municipalities that use this SUDAS document. So we felt that was a good resource to check our document against. And then we also, I know I talked a little bit about the AIA general conditions contract. We also compared it against that for some reference. As far as work completed to date, one of the things I really want to point out here, once we did our internal review and legal review on it, we actually worked with the Sioux Falls Contractors Association on these changes. And the Sioux Falls Contractors Association is a subsidiary of the state AGC organization. I know the state AGC, they work with the DOT when they update their standards. Similarly, we wanted to work with kind of the industry representatives here. And again, those are represented by the Sioux Falls Contractors Association. We actually had multiple meetings with them, I believe 5 or 6 meetings, just to kind of vet through all the changes, kind of a little give and take back and forth with each one. But ultimately, we received their approval that they supported the changes we were making. So for us, that was because some of these items can be kind of controversial each way, and to garner their support for these changes, that was actually a big win for us. And then we also made an informational presentation in May of 2016 to the Infrastructure Review and Advisory Board. And as far as the timeline, what we're proposing, pending land use approval, we'd like to bring these to the City Council for approval for a resolution. And then once that is approved, then we'd like these to go into an effect September. And basically, most of our projects this year have already been bid. So our ultimate goal is to have this in place for the 2017 construction season for all those projects that'll be bidding. And some of those could start bidding even late in the year. So I'd like to do now the next series of slides. I'm just going to go through some of the highlights, some of the major changes that we made to the document. There are several hundred changes that we made, all the way from changing abbreviations or just minor, maybe just some grammatical clarifications. But the things I want to focus on are the substantial or the substantive items for us. So I'll go ahead and start doing that. And Section 210.C, non-responsible bidders. What we did there is we added language to what constitute a non-responsible bidder. What this does is it protects the city from having an unqualified or low-quality bidder from performing work. And I'd like to add that for us, we're not really changing how we've done business. What we're doing is kind of formalizing it, putting it in the specifications to how we've been doing business to provide some clarity. This is probably one of the things that was certainly garnered a lot of contractor interest on our end. And it's actually something that entities have really wrestled with. But one thing I'd like to point out is the language that we're adding here is very similar language to what the DOT just added to their standard specifications in their last round of updates within the last couple of years. Some things that might constitute a non-responsible bidder, if they have incomplete projects with us, or if they have projects that are in default, claims against them, multiple projects where they failed to complete the work on time, or products that didn't meet the specifications. So those are generally outlined. And kind of the third bullet point there is we want to also point out that we require documentation when we're substantiating this. We have a responsibility to award to the low bidder unless we can prove otherwise per se. And we want to make sure we can't go on hearsay, hey, we heard that contractor did a bad job. We need documented proof, like from other cities or communities, that, hey, they didn't get their jobs done on time. Or the same thing with us. I know when we run into issues with our contractors, the first thing Diane and her team will say, where's the documentation? So for us, it's all about getting, if we have a contractor performing poorly, we're wanting to make sure that we're documenting that. A couple sections here in sections 2 and 3 as far as bidding requirements and conditions, as well as the award and execution of the contract. These sections were merged with the instruction to bidders. Basically, the instruction to bidders is another document that when the contractor comes into our office or when they download a set of plans, they download the plans and specifications. Part of that specifications, it includes an instruction to bidder sheet. Talks about stuff like insurance requirements, when and where the contractor needs to submit his bid at, There was some kind of overlap and duplication between what we had in the instruction of bidders as well as the general conditions. So we just kind of cleaned that up. More permanent stuff went into the general conditions. Stuff that may change, like a tweak on insurance form or something, we put in the instruction to bidders. And then, yeah, I guess I kind of went over those two other bullet points there. The next section that we changed is differing site conditions. It's a new section that's added to outline the procedures to follow if differing site conditions are discovered, and requires the party discovering the differing site conditions to promptly notify the owner or the other party, and written notice is required. You know, what that means is parties have a responsibility to notify us if there's an unknown that they encounter. For instance, an example may be if the soil borings show that, hey, it's just dirt here and they're putting in pipe and they encounter rock. Well, rock is a differing site condition. They are entitled to additional payment for that. It's a lot more intense excavation. They may actually have to bring in a blasting company to use dynamite and shoot the rock out. So that would be a differing site condition, but all we ask from them is they have to notify us, you know, in writing. They can't wait till the end of the project and say, oh, by the way, we had some additional money coming to us. That's not how we do business. So this just kind of formalizes that. Very similar in section 518 here, claims for additional compensation. It clarified the requirements for submitting written and oral claims for additional compensation, and anything orally they have to follow up within writing. Otherwise, they're not going to get paid for the additional work. And then additional claims, they have to provide written claims for breakdown of the materials, labor, equipment, and costs necessary to complete that work. You know, again, kind of same thing what I just explained in the differing site conditions. They have to notify us if they think they're entitled to more money. You know, we allow some oral notification at first. Maybe they're digging. They don't quite know if they need to do additional work yet. Hey, the contractor may say, hey, we think we might have something going on here. That allows us to go, hey, we can start keeping track of their hours, the equipment they're being used. So again, we're not 6 months down the road trying to argue about what happened, because memories become it's more complicated 6 months down the line. And again, same thing here. There's a time frame of 10 days that they actually have to provide that written notification to us. Again, they can't come back 6 months later. All right, the next section, section 8.1 in the no assignment of contract. This is a new section addressing subcontracts and the contractor's responsibility for the work. In essence, our contract is with the general contractor. We don't get into subcontract agreements. If we have a contract with contractor X, that's who we work with. We don't work directly with his subs. The general contractor has to control and manage his subs. The other thing that this is really saying is, the third bullet point there, the contractor cannot sell, transfer, assign, or otherwise dispose of the contract. What that means in practical terms, if contractor X gets the bid, he can't come to us and say, you know what, I sold the contract to somebody else, or I want to give it to somebody else, and this other contractor is going to furnish the bonds and the insurance and everything for us. He actually has to be the bond holder. He actually has to be the insurance holder for us. He can still have subcontracts, and he can subcontract out most of the work, but our agreement is still with that prime contractor or that general contractor. Liquidated damages. We just updated this rate sheet to align with what the DOT has done with their standard specifications. And what this means is if a contractor does not meet his contractual obligations and does not get done within the time specified, he gets assessed liquidated damages for every day that he's not done. And it's based on the dollar amount of the contract. So for instance, if we just pick out the second row of that contract, if it's a $50,000 to $100,000 contract, if he doesn't meet his contractual obligations, we would assess liquidated damages of $450 a day that we would deduct from the contract value. And that's something we do occasionally to frequently with our contracts. It's just something we follow the contractual obligation. If they don't get done on time, we we withhold monies for that. And I will stress here, the term liquidated damages, it's a kind of a it's an agreement between the contractor and the owner for what we think the actual damages would be to the owner as far as loss of use, additional overhead from, we have additional staff time we have to spend on the project and whatnot. It's not a penalty because the courts frown upon, if you want to call it a punitive penalty against a contractor. So that's why it's a term called liquidated damages. And that's an industry standard term. Breach of contract, we updated several criteria and added a criteria for finding a contractor in the breach of contract. Additional language about the city taking over the project in situations of breach of contract, and then added additional language about the city's remedies for recovering damages. Without getting necessarily too into the details here, if a contractor defaults, if he goes bankrupt or something like that, that's why we have bonding companies standing behind the contractor. We just wouldn't rush out and go hire another contractor. The courts will dictate that we have to work with the bonding company first. The bonding company then would either come in and hire their own contractor, or maybe they work with us and we'd hire another contractor and they'd pay the difference. Bonding companies are set up so the city doesn't have to pay additional monies for for the original contract amount. And some of this language that we changed just clarifies that language and the responsibilities with the surety company. The next section, termination of the contract for convenience. Basically, it's a new section outlining the termination of the contract without cause. And then the contractor gets compensated for the work he's completed to date. So an example I would use, let's say the 12th Street Bridge this year. We bid that early in the year, and I believe it was right around a $7 million project. I believe we bid it in January, if I'm not mistaken. Let's say we had a natural disaster come through. Let's say we had a large tornado came through and just wiped out a large part of Sioux Falls. Obviously, our priorities quickly would change. We may want to go, we need that $7 million for something else, so we could terminate that contract. Now, we'd have to pay them for work completed. Maybe they had the girders for the bridge already ordered and paid for. Obviously, we would have to pay them for the services rendered to date, but we could actually get out of the remainder of the contract. These next two sections, as far as progress payments and decisions to withhold payment, it's just clarifying and adding language as far as when we can withhold payment from the contractor. Essentially what we're saying, if the contractor is not doing their job, we're going to start withholding payment from you until you are doing your job, according to the plans and specifications. Final payment, basically, the contractor has to be free of all liens and other indebtedness before we make final payment to the contractor. So if we get liens and stuff from subcontractors that they're not getting paid, we're not going to make final payment to that contractor until that is cleared up. Claims and disputes, the procedures and the remedies. Again, this is also a new section addressing claims and dispute procedures and remedies. It describes our process to follow in resolving claims prior to dispute and litigation. And basically, we kind of have 3 steps. And again, this is very similar. We're not really changing the way we've done business. We're just clarifying it, written. We're putting it in writing. And basically, 3 steps, negotiations, if you want to call them formal and informal negotiations, all the way from our project manager or through Josh and Brad or through even our city engineer or public works director will get involved depending on the type of claim that's out there. If all that fails, then we have the option to go to voluntary mediation. And if that doesn't work, then we may end up in litigation. Section 11, we added some new sections for a variety of items. I'm not going to try and get into all the legal terminology there. One of them, the first bullet point though, we can't do a project without city council fund obligations for so for some reason, the city council would de-obligate funds to a project or something, we can't continue with the contract. The others, severability, waivers of future performance, neutrality, legal notices, applicable law. If you want to know more information, Diane could certainly help talk through the legal items there. So with that, that was just kind of a brief overview of the changes that we had. So I'd be glad, or Josh, Brad, or Diane would be glad to answer any questions.
Thank you very much, Shannon. Questions, comments? Councilor Neitzer.
Has this been looked at by stakeholders in the industry or any boards, such as would IRAB be the appropriate board, and what was the comments?
Yeah, we had brought it in May, an informational session to IRAB, so they did hear this. They didn't have any comments on it. From the IRAB board, there's not a lot of the IRAB boards composed of developers, utility companies, and stakeholders like that. So we brought it to them because we need to bring infrastructure changes to them. But our big thing was we did reach out to the Sioux Falls Contractors Association, though that really is the sounding board as far as who is affected by these. And we had great participation in the meetings with them. They actually brought in, William, help me out, was there probably 6-7 people that were consistently meeting with you? Yeah, they had at least a half dozen people that I had mentioned that we had met with them, 5 to 6 times. They had several of their representatives at the table on that. They actually had the AGC attorney was vetting through this. The executive director for the AGC, which is also the kind of the local Sioux Falls Contractors Association executive director, he attended those meetings. So from our standpoint, it was very well vetted through the local industry.
Okay. Yep. Any other questions or comments? Councilor Staley.
Looking at section 210C on page 4, and that you're talking about those non-responsible bidders, people who have like a bad history with the city, or not necessarily with the city, but just in other states, I think you said. How are we handling that now? A non-responsible bidder because we were talking about is it Thursdays that they take bids for things, and that there already is kind of something in place for people with bad reputation, so to speak.
We already, again, we're not really changing the process. We've informally done this. We're just putting it into writing as far as how we would disqualify bidders. I mean, we're going to...
Never been written down, you mean? This
Correct.
has just been, okay.
Correct.
Then I have a question about on page 5, section 4-2. In his time, you were talking about how, and by the way, I really appreciate how you were describing things. You're very good at just getting the point across. Bravo on that. But how is that, the site conditions, somebody's digging in and then they find something different going on. Is this something you're just clarifying again, writing down, or has it been handled differently in the past?
What section?
It's on page 5.
It's section 4.2, differing site conditions.
That if they run into some dirt they weren't expecting, that they're notifying you. Is that something that, how have you handled that in the past?
Same thing. It just provides some more clarification to how we're doing business.
It hasn't been, okay, it hasn't been written down. Is that, okay, and then the next thing is, we're on page 6, section 8.1. How often does it happen that they try to sell off contracts to other people? It doesn't happen?
Thank you. That language was included to avoid that circumstance. it's my understanding that it is not, there's not been an issue with that in Sioux Falls. But it is language that is used elsewhere, and the idea is once we have a qualified responsible bidder, we want to make sure we work with that qualified responsible bidder rather than having them sell the contract to someone who may not meet the standards we require.
But it has, you don't think it's ever happened?
I've been told that it has not happened.
Okay.
I'm not aware of it happening either. And that kind of goes into the reviewing the other industry documents. You know, that was one of those items that, oh, we don't have this, and, you know, to protect our interest, it was recommended that we include that just to protect us from the what-if situation.
Okay, one more question on page 7, and then you're talking about those, when you can terminate something, and he used the 12th Street Bridge, or if there's some disaster, is that like the only time you would be terminating someone's contract then, would be like a natural disaster, or could the city ever just change something on, pull the deal out from somebody midterm?
Yes, I think you were talking about the termination for convenience clause.
Yes.
And what that really is government entities have these clauses, and it isn't seen probably elsewhere in the private industry, but it is with government entities because they do have that competing need sometimes to redirect funds to respond to an emergency elsewhere. It's not that the project is in jeopardy from an emergency or that the road itself, the area was flooded, but that there was a flood elsewhere in the city or a tornado elsewhere in the city. And the only way that the city can protect itself when you get to these multi-million-dollar situations where responses are necessary is to be able to pull those, possibly pull those larger contracts. Now, having said that, as you would undoubtedly expect, courts have said that those sorts of clauses are permissible, but that there's a higher standard. When we breach a contract or when we terminate a contract, there's a higher standard against the city. And above all, what you do is you pay for work that's already been completed. You cannot get out of that, obviously, to go and spend money elsewhere. And then the prudent thing to do, and the things that the court would look at is, have you figured out an acceptable plan to wind down any work that's already been performed? Now, the example Shannon gave was a contract was awarded, materials have been ordered, but work has not started yet. We pay for the materials, then we terminate the contract, move on to respond to the other issue. If work has been started, easiest example is we've got a project doing 8 blocks of street. We wind it down at that 4th block, pay for that. I mean, you can't just stop construction the day the emergency occurs maybe, but you wind it down, stop the contract, pay for what you've been doing, and then redirect the funds. So those things, you know, are very important to that process. And then, of course, the courts would look very, very stringently at, is this a substantial reason? What is your reasoning for doing this? And if it's a whim or politics, the courts are not going to look kindly on that, and they're probably going to say that it's an unlawful termination. So
but like, what's the status now when we'd have something like that? Since this is a new thing, or is this?
Under general state law and under the city's existing standards, we would be able to terminate if there's a breach of contract, which is also in these standards. We would be able to terminate if there's an emergency affecting the exact project you're working on.
So this is widening the scope of what could
Right.
cause for a termination.
Right, but we would not be able to redirect those funds. And, you know, part of the looking at this, these disasters so rarely happen, you think, really? Are we ever really going to need that? And I guess I would point to you, timber strike with our ice storm, certainly Missouri River flooding elsewhere in the state. Things do happen. And so it's the very rare circumstance where this would occur.
Thank you.
Again, I'm not aware of any time we've ever had where we would have, well, it's a new clause for us, so we never terminate a contract for convenience. Similar, again, reviewing these other documents, we've seen that clause in there, felt that would help protect the city's interest. The other example, I know we gave some examples of natural disasters. You know, another thing is maybe there's some national, I'll just call it a calamity, and maybe our sales tax revenues drop by, say it's 30%. Well, then we would want to maybe consider reallocating resources or something like that. So that's another, it's not just natural disasters that could cause the policymakers or decision makers to want to change the course on a project.
I guess my concern would be that that we could have a project started and then we decide we don't have enough money for it and then we pull the plug on that person. And, you know, I wouldn't want that to happen to the...
Correct, and that's why the provisions are in there for paying for work completed today. We would not leave a project, you know, we'd have to evaluate the project where, like 12th Street Bridge, we wouldn't stop it halfway. We would say, we'd have to make a decision and go, we're not starting this. We're not going to tear down the old bridge even. Or if we had a street half tore up, we're going to finish that street. Worst case scenario, maybe what we'd have to do if it's a 10-block street, maybe we do 5 of the blocks and not start the other 5. But it's hard to play what-if scenarios with that. So,
right. Thank you, Shannon. Councilor Selberg, any comments or questions? Okay. Councilor Neitzer?
One last real quick follow-up from what Councilor Staley was mentioning. Is there any recognition of the fact that, you know, I may dedicate a lot of resources and know that I have a project that's going to last several months if I'm a contractor, and then if the project gets canceled, I get reimbursed for, you know, what I've done so far, but I now have, you know, maybe I have a lot of idle employees and it's maybe too late to bid on other things. There's maybe, you know, the next several $1 million of work that I was going to bring in, but now I don't. And now, you know, I'm kind of in the lurch.
That's an excellent point. That's actually one of the very questions or concerns that came up from the contracting industry. I know this is a clause that we want to be very responsible with. You know, it kind of like Diane said, how the courts play out. If the assistant city engineer is mad at a contractor, we can't just terminate the contract. You know, there has to be some sort of rationale for it. And that's what, you know, whether it's funding, natural disasters, but we do want to have that ability to do that, so.
Okay. One more?
One more.
Yes.
Should there be was there a thought of maybe narrowing the scope and saying, you know, an act of God or a natural disaster or some sort of...
Can you repeat the question? I guess I didn't quite hear it.
Was there any thought for that particular determination for convenience clause of adding a qualifier that you could only do it in certain cases, for example, a natural disaster, act of God, something like that, to codify the reasons why we can do it so that there's no way that you can just do it willy-nilly?
We had discussions back and forth with the contracting industry, and specifically we did not include that because this is a termination that is for other reasons than by cause when there's a breach of contract or things like that. So we did it specifically to give us the flexibility. This is a protection for the city. It's not for the contractors. It's a protection for the public. Now, like Shannon said, and Diane said, there is a high standard in the courts, and if we don't do it for a very good reason, we will lose in the courts, and the contractors will be awarded maybe some reparations. The other thing is, if we do this without good cause, and we get the reputation of that, we will lose bidders. Contractors will not want to take that risk, and the contractors that do will increase their costs. So it's not in the best interest of the city to do this capriciously. We want to make sure this is this is for a very good reason, and it's not something we use frequently. Through our discussion with the contractors and their attorneys, they felt comfortable with the language in here. We debated this for a long time, and finally they felt there was enough legal protection and enough protection just the way the city operates that they felt comfortable with it being included in our provisions.
Okay, thank you very much. While this is maybe not the most glamorous work to conduct, I mean, revisions to the general conditions for public improvements, it is very necessary work because the clarity that it brings of responsibilities and the process and procedures for this, both for the city and for the contractors certainly does pay big benefits and dividends down the road, having that clarity up front. Not only for us, but I would argue that it pays for the contractors too, because they know exactly what their responsibilities are and their obligations, so they do not get themselves into a situation that maybe is not desirable. We'll leave it at that. But thank you for the work in terms of involving the other organizations, IRAB and the Sioux Falls Contractors Association, as well as the general contractors too, and in the comparison with the other industry documents that you used as well. Just one quick question, Shannon. Just how long did this process actually take in order from start to finish?
2 years? August of 2014, when we
August
started our review.
Okay, that's what I thought. Wow. So thank you very much, and I do especially I like the little summary synopsis that you provided here at the beginning of your presentation too, the 3-page summary. So Shannon, thank you very much, and everybody else involved, thank you for the presentation. That leads us now to open discussion. Any items for open discussion?
Mr. Chair? Pardon me. Did you need the committee to vote to take it out of committee to forward it to the city council?
Yes, I believe so, because council will approve these via resolution at the council meeting. So whatever steps we need to have land use endorsement.
Okay. Anybody, I guess, not in favor of wishing this to go forward to the full council?
You would need a motion,
Yes.
a motion, please.
I'll make a motion to move this proposal onto the full city council.
Second.
Okay, all in favor?
Aye.
Aye.
Opposed? Okay, motion carries. Okay, now that leads us to open discussion. Hearing none, this meeting is adjourned.